Hi, I'm Dr. Roger Cohen. Today I want to talk about civil rights in America. This lecture will be looking at the civil rights in America discussion, and I'm looking forward to our deep dive today. So I'd like to begin by asking the question, think about a right you exercise every day, the ability to go to school, the ability to go to work, public act spaces without being turned away from because of who you are. Now, I want you to consider who had to fight to make that right a reality for everyone. Now, this chapter traces America's long, unfinished struggle to make its founding promise equality, liberty, and justice real for all its people. As we'll see, these were never simply gifts granted by the law. They were won through court battles, through protests, through legislation, and cultural change. So let's set the stage. Why do civil rights matter? The Declaration of Independence proclaimed that all men were created equal, and the Constitution, as originally written, explicitly denied people rights to large portions of the population, enslaved people, women, and non-white citizens. We will be using our time to close that gap. That civil rights are not the same as civil liberties, of course. Civil rights protect individuals from government overreach, like free speech. Civil rights ensure that groups are treated equally by the government and institutions. So the fight for civil rights has historically moved in waves: racial equality, gender equality, LGBTQ plus rights, each building on the gains and strategies of those that came before. And progress has rarely been linear. For every major gain, there's typically been significant legal and social resistance. So today we're going to look at how and what you should expect that civil rights are, and at their constitutional foundations, what they are, and the three judicial standards courts use to evaluate judicial laws. We're going to look at racial equality struggle. We're going to look at women's rights and LGBTQ plus movements as landmark constitutional cases. So let's start with the fundamental question: what are exactly our civil rights? And where do they come from in our constitutional system? So, civil rights are constitutionally supported guarantees that government officials treat citizens equally, basing their decisions on merit rather than race, rather than gender, rather than religion, national origin, or other personal characteristics. It's based on merit. Civil rights protections don't mean everyone gets identical outcomes. That might be something different. They mean the process must be fair and non-discriminatory. A university can reject an applicant for poor grades. It cannot reject them for the basis of their race. So let's put this in the historical context. Discrimination in America. The United States founding principles are liberty, equality, and justice, but for much of its history, those principles applied selectively. We must uh, look at the scope of our historical discrimination. Federally funded sterilization programs operated in 32 states throughout the 20th century, with California leading the nation in procedures performed. African Americans were denied citizenship, voting rights, education, and property ownership through explicit legal structures. Women were barred from voting until 1920, and many of the professional fields well into the 20th century. Discrimination based on religion, national origin, ethnicity, and sexual orientation has always been embedded in American law and custom. So, what are the constitutional sources? There are two key constitutional sources for civil rights protections that students must be you must be aware of. That one is the Equal Protection Clause of the 14th Amendment from 1868. It applies specifically to state governments. It says no state shall deny any person in its jurisdiction the equal protection of the laws. This was passed after the Civil War to protect newly freed Black Americans. And the Due Process Clause of the Fifth Amendment applies to the federal government. Because the 14th Amendment only restricts state actions, the Supreme Court interpreted the Fifth Amendment's due process guarantee as implying an equal protection requirement under federal laws. So there is a nuance. Private actors, employers, businesses, landlords are not bound by the Equal Action Protection Clause. Congress has passed those several anti-discrimination laws, like the Civil Rights Act of 64, that apply to private entities, and these constitutional and statutory protections all work together. So there are three standards of judicial review. As you see on the screen, that not all discriminating laws are judged by the same standard. Courts use three different levels of review depending on the type of classification being used. So, can you think of a law that treats people differently but is perfectly legal? Why might the government be allowed to classify people in some ways but not in others? Like minimum age to vote, maybe, or driver's license required to drive, or minimum age requirements in order to minimum wage in order to work. So, what are the three standards for judicial review? The first standard for judicial review is called strict scrutiny. Um, so, before we get into this strict scrutiny, let's think of a burden of proof spectrum here. At the low end, there's the government barely has to justify itself, and at the high end, the government must show the classification is absolutely necessary. So, in strict scrutiny, the highest and most demanding standard applies when the law discriminates on the basis of suspect classification. At a category that has been historically subjected to purposeful discrimination is immutable, which means not easily changed, and is related to a person's ability to contribute to society. Suspect classifications include race, religion, national origin, alien immigration status, and the test for this is the law must be necessary to achieve a compelling state interest. If it's necessary, it means there's no less discriminatory alternative. Compelling means the interest must be extremely important, not just convenient. So the burden of proof to have strict scrutiny in order to uh, is that the government must prove the law passes the test. Almost no law survives strict scrutiny in America. Key case here is Korematsu versus the United States in 1944, when FDR ordered Japanese Americans, two-thirds of whom were citizens of America, into internment camps. And Korematsu, the Supreme Court applied strict scrutiny for the first time to racial discrimination, establishing race as a suspect classification. Shockingly, the court upheld the internment, finding a compelling interest in national security. This remains the only racially classification to survive scrutiny and is widely condemned today. In 2018, the court formally repudiated Korematsu in Trump versus Hawaii. The second standard is immediate scrutiny. This test only applies to quasi-suspect classifications that primarily gender and legitimacy, whether the child's born inside or outside of marriage. And these groups have faced discrimination, but courts have judged them to be flexible as needed. The law must be substantially related to a significant government interest. Both substantial and significant are lower bars than necessary, and they must be compelling. There must be a burden of proof still on the government, and it must show an exceedingly persuasive justification. The key case here is United States versus Virginia in 1996. Court struck down military institute's male-only admissions policy, finding Virginia's justification for excluding women were neither genuine nor supported by evidence. The last one is called the rational basis review, and it's the lowest standard applied to most classifications based on age, disability, economic status, and virtually everything. Most laws will survive this if the test is the law must have a rational relationship to any conceivable legitimate government interest. The burden of proof is on the challenger that the person arguing the law is unconstitutional or show no rational basis exists. And you must show intent. Even if this law has a discretionary effect, equal protection violations require intentional discrimination. So the intent can be shown that there's facial discrimination. The law explicitly classifies by race or gender. Discriminatory application, meaning it's neutral on its face but applied differently to different people, or it's discriminatory motive, meaning people they are passed with the purpose of harming a group. So statistical evidence alone is not enough or sufficient to prove discriminatory intent. With these tools in mind, they've been applied in the most of the contentious areas of our civil rights history in race. So the origins of our race inequality or equality struggle begins with the uncomfortable truth that the United States was founded on a set of ideals that did not practice. The narratives of white slave owners used to justify slavery created an image of an inferior race, requiring white mastery. And those narratives outlasted slavery itself well over a century. So in 1857, in Dred Scott versus Sanford, the Supreme Court ruled that African Americans were not black citizens and could not sue in federal courts. Chief Justice Roger Taney wrote that black people had no rights which the white man was bound to respect. So it pushed us towards a civil war. In 1865, the 13th Amendment was codified, abolishing slavery, but immediately the Southern states passed black codes, laws prohibiting freed black Americans from voting, owning property, or attending school. The legal form of slavery was gone, but its functional replacement arrived almost immediately. In 1868, the 14th Amendment granted citizenship and equal protection to all born in the United States, including formerly enslaved people. This was a legal weapon in the civil rights movement and would eventually wield the most effectiveness, but it took nearly a century to fully deploy this. Supreme Court in Plessy versus Ferguson, 1896, upheld racial segregation under the separate but equal doctrine. Homer Plessy, who was 7/8 white, challenged a Louisiana law requiring separate train cars. The court held that separation didn't imply inferiority and that the ruling authorized the entire Jim Crow system that went on for 58 years. By Brown versus Board of Education, Chief Justice Earl Warren wrote a unanimous opinion declaring that the separate but equal concept of Plessy versus Ferguson was inherently unequal and that it was unconstitutional and overturned it. By the Civil Rights Act of 1964, the JFK initiated and shepherded through Congress by LBJ after Kennedy's assassination. It was passes the Civil Rights Act of 1964, and it prohibited segregation in public areas and places, banned employment and discrimination based on race, religion, origin, and sex. And it also created the Equal Opportunities Commission, EEOC, to enforce these. So we are then left with multiple types of discrimination, de jure and de facto discrimination. After the Civil Rights Act, a question emerged. Did the law actually end discrimination? So de jure discrimination is discrimination by law, was ended by legislation and court decisions. Jim Crow laws were struck down. Schools were ordered to desegregate. De facto discrimination, which is discrimination in practice, proved much harder to eliminate. Residential segregation in the North, shaped by decades of discriminatory housing policies and economic disparity, was a problem, and it persisted even after the laws changed. The irony, ending de jure segregation in the South exposed the limits of legal change in addressing de facto segregation in the North. What we came with afterwards was affirmative action. When a court finds that a government agency has engaged in racial discrimination, it may order affirmative action, a race-conscious remedy to help end discrimination and ease its effects. This is permissible under the Equal Opportunity Protection Clause because it narrowly tailored to a further compelling interest in eliminating discrimination. So, the civil rights movement itself. The civil rights movement is often remembered through the lens of a few key figures. It was fundamentally a multi-front strategic campaign, emphasizing to students that, and it emphasizes that the movement's leaders made deliberate, calculated decisions about how and where to fight. There are four key strategies that came out of the civil rights movement. Founded in 1910, the NAACP's legal team by Thurgood Marshall developed a long-term litigation strategy. He chose to attack segregation in a professional education first, which is law schools and graduate schools, calculating that the Supreme Court would be able to get rid of separate but equal. Rosa Parks was arrested in 1955. The Black community of Montgomery organized a 381-day boycott of the city bus system, and the economic impact made up of by African Americans, who were 70% of bus riders, demonstrated that purchasing power could be a powerful political motivation for change. The civil rights movement made a brilliant use of the television. You'll see peaceful protests and scenes of peaceful activism coming through the media. And also, then the movement ultimately had to pass by Congress, where Kennedy and Johnson were both pressed hard by civil rights leaders. And Johnson, and after Kennedy's assassination, but used the political spectrum to pass the Voting Rights Act of 65 and the Civil Rights Act of 64. When we look at the case of gender, the just as racism is pervasive, often unrecognized, and deeply embedded in cultural narratives, so is sexism. The women's rights movement is commonly dated from Seneca Falls Convention in 1848, but its roots go back to the earliest days of the Republic, when women like Abigail Adams implored her husband to remember the ladies during drafting the founding documents. This widely accepted narrative kept the wealthy white men out of public life, and that they were too good and pure for the corruption of politics. This framing, which praised women even as it excluded them, was particularly insidious form of discrimination, making subjugation appear like reverence. So we'll see that women's rights go through four major milestones as listed here, ending with the Lilly Ledbetter Fair Pay Act, and uh, we must give nod to Ruth Bader Ginsburg, who pushed through legal cases and pushed the glass ceiling of women in the 1970s and broke through with many movements of equal pay for women in the 1970s. So both the racial and equality and gender equality movements have won significant legal protections. The newest movement we see in America is the LGBTQ plus movements that are happening, ending recently with Obergefell versus Hodges. The ruling found that the fundamental right to marry under the right to privacy is guaranteed to same-sex couples within marriage. So these landmark cases are victories. They are significant, and there are still discriminatory actions that are being pushed out through the courts at this time. There are some key terms I want you to take away with today, and some of these key terms that are really important are Jim Crow laws, de facto discrimination, de jure discrimination, the Equal Protection Clause, strict scrutiny, civil rights, and the Civil Rights Act of 64, and the glass ceiling. I'd like to thank you for turning in today to this lecture, and I look forward to more time with you in the future.